right. Thank you everyone for joining us, and thanks again for your patience. My name is Dustin Saldarriaga. I'm a senior associate at Scott Legal PC. And today we're going to spend some time talking about moving from a non-immigrant visa to a green card. This is a very common topic of conversation at our firm with our clients. One of the most common questions that we receive. And today we'll be focusing on the employment and business green card options. These include the EB-2 and the EB-5, and we'll also be discussing options for entrepreneurs, those who are self-employed. Today, we're very fortunate to have our firm's founder, Ian Scott, here to speak with us. Ian has significant experience helping clients navigate the process from a non-immigrant visa to a green card, and he's personally navigated a number of the non-immigrant visa options. In fact, he currently has an E2 visa, which is what he used to establish our law firm. A few things before we get started. Our firm is a full-service immigration firm, so though we do focus on business immigration, we handle the full spectrum of immigration cases, from family immigration to humanitarian immigration and everything in between. So if you do have any questions that come up, please do reach out to us. We will be continuing this webinar. We try to do at least 2 of these webinars a month. And we do these on a range of immigration topics. So at the end of this webinar, we'll send you a link where you can sign up for our future webinars. In that email, we'll also send you a copy of the PowerPoint that you see on your screen, as well as a link to our YouTube channel. This webinar is being recorded, and we do post our webinars to our YouTube channel. We also post shorter videos that run the full spectrum of immigration topics to our YouTube channel. So please do check those out. We try to make them high quality and to put really the best information that's available on our YouTube channel. If you do have a question over the course of the presentation, feel free to use either the Q&A box on Zoom or the chat function. I will be monitoring those, and we'll either ask Ian in the middle of the presentation, or I'll save the questions for the end. But either way, we do plan to get through all of the questions that come in. So without further delay, I will go ahead and pass it off to Ian.
Thank you very much, Dustin. It's great to be here. So as Dustin had mentioned, we are going to be talking about moving from a visa to a green card. And I think that before we kind of start getting into the specific green card options, I wanted to spend some time really just talking about, how the green card system in the United States works, because it is very different from many countries. And I say this because a lot of other countries, they have a system for permanent residency, because the green card is the equivalent of permanent residency. They have a system where the individual accumulates a number of points based on criteria that are set by the government. So one could be how long the person has been in the country on a valid visa. The other could be their education level. Another could be their fluency in the language of the country. It could be their work experience. Age is sometimes a factor in terms of getting more points the younger that you are. But a lot of these countries have what's called a points-based system, and then once you've accumulated enough points, and you can accumulate these points from different in different ways, then you're eligible to apply for permanent residency. And one of the key things that are usually included in those systems is how long the person has been in the country under valid immigration status, right? So, but unfortunately, the United States doesn't do that. The United States just has a list of green card categories, and if you're eligible for those categories, you can apply. And the non-immigrant visa categories, the categories such as TN or E1, E2, H1B, L1, etc., the non-immigrant categories don't really put you in any better position to apply for a green card. The key is really just, are you eligible based on the green card criteria? And so there's no non-immigrant visa that leads to a green card, right? You have a non-immigrant visa for 5 years, and after 5 years, you get a green card. That concept does not exist in the United States, and instead there may be non-immigrant visas that look similar to green card categories, but the green card category is separate and independent, and you must look at the individual requirements for each category and see if you actually meet it. Now, in terms of there are a few different green card categories, but the two key green card categories are either family-based or employment-based green card categories. And when you're looking at the family-based green card category, that is going to be further broken down by what we call immediate relatives and a preference category. And immediate relatives, unfortunately, don't translate to what we would normally think of as immediate relatives. It's a defined term by the U.S. government, and it really means a child, a U.S. citizen over 21 that is sponsoring their parent, or a spouse, if you're sponsoring a U.S. citizen that's sponsoring a spouse. Those are immediate relative categories. And there's definitely some advantages with respect to the immediate relative category in terms of speed of processing and the priority really that the U.S. government puts on this. Everything else is what we call put into a preference category. Now, the reason this one is not as good as the immediate relative category is because the preference category does have a limit to the number of green cards that can be issued each year. So once that limit has been used up, then people start to go on wait lists. And the wait lists for almost every category, in fact, I think for all of the preference-based categories right now, there is a wait list. I think the very last one where there wasn't a wait list, I believe that at the end of August is moving to move to a wait list as well. But the wait can be quite extensive because, for example, if a U.S. citizen wants to sponsor their brother or sister, the wait time can be 14 or 15 years before the green card would be available. Now, the other thing I just wanted to kind of point out is that concept of that wait time really extends through the employment-based categories as well. And the concept is really that for green cards, for everything except the immediate relative category, the government can issue a certain number of green cards per year, and then that's further subdivided by country. And once they hit those limits, then people have to start to go on wait lists. And sometimes, as I said, those wait lists can be quite extensive, but the exact same concept applies under the employment-based categories, and we are seeing, quite extreme wait lists for almost all of the employment-based categories as well right now. So something to keep in mind, and we will talk about that a little bit more as we move forward. So now, when we move to employment-based is broken down really into 5 different categories, and it's EB1 through EB5. And we're going to talk about each of these with the exception of EB4, which is a religious-based green card. But each of these just have separate criteria that we're going to spend some time talking about as we go through the presentation. So we talked a little bit about the family-based green card already. Often when we're looking at people moving from a non-immigrant visa to a green card, this often comes up. Someone's on a TN visa and they meet the love of their life and they get married, and the person is a U.S. citizen or a green card holder, and then they apply for a green card. So that happens quite often. The other thing that happens quite often is that maybe they already have relatives. Maybe you have a parent, a U.S. citizen parent in the United States, and let's say you're married over 21 or not married over 21. And the U.S. citizen parent might be able to sponsor you for a green card. But again, the U.S. citizen parent, even though it sounds like it's immediate relative, that would fall under the preference-based category. So there would be significant backlog there. Now, in terms of the process, and I think that when we're talking about the process, I know we're on the family-based green card slide, but I would think about this process as that works the same for all green cards. And that is that there is a 2 or 3 step process, right? And we'll talk about the difference between a 2-step and a 3-step process. So there's always going to be at least a 2-step process. So the first step of the process is proving objectively that you meet whatever the requirement is. So let's say that you marry a U.S. citizen, and you have to prove that it's a legitimate marriage. So that's what the first step is, and that's going to be filing an I-130 in this case. But if we were under employment-based, then let's say that we were under one of the employment-based categories, we'd have to prove whatever it is or was that was required for that particular category. So if we were doing extraordinary ability, we'd have to show that the person had extraordinary ability. And that's always going to be the step one, right? So then we're always going to have at least a step two. Now, the step two is going to be going to be the same across all of the different visa categories. So if whether it's a family-based or whether it's an employment-based category, the person is either going to be adjusting status in the US, which means they're in the United States and they're filing paperwork for the green card in the United States, or they're going to be doing consular processing. So they can either be outside the United States or they can be inside the United States, and we're filing consular processing. So it's just really two different ways. And whenever we're deciding which one we're going to do, it's going to depend on strategy, because it's not straightforward with respect to making the decision with respect to which one we're going to do. If you are in the United States and you file an I-485, then you are going to file for employment authorization and travel authorization along with that I-485, and it's going to take maybe 6 months to a year to be able to get those approved. But once those are approved, you're going to be able to kind of move back and forth. Now, the other concept, and again, I know this is the family-based slide, but these concepts apply through all of the employment-based categories. The other thing is that the consular processing, the step two, you can only do step two if the category is current. So as I spoke about earlier, that the preference-based categories, a lot of them are not current, right? So let's say that it was September and someone was on a TN visa, and then they met the love of their life, and they decided and that person happened to be a green card holder, and then they decided they wanted to get married. Well, in September, the preference category for green card holder marrying someone is no longer current. It's current in August, not going to be current in September. So what that means is that if the person was in the United States, they would not be able to file the I-485 because the category is not current. And similarly, in that example that I gave you, if a US citizen sibling wanted to sponsor their brother or sister, and they filed an I-130 petition and said, hey, we're brother and sister, here's their birth certificates, and they wouldn't be able to file the I-485 for 14 or 15 years. So there's no benefit that is afforded to the person during that time. So something to keep in mind. But you're always going to be looking at this kind of concept of objectively, what are the requirements for the particular visa category. And that's going to be step one. And then B, you're going to be looking for step two, you're going to be looking at, can I file the I-485 or do consular processing? And then if you can, you're going to have to file the documentation for that. And if you remember, I said that there could be 3 steps, because there are some categories, both in family-based and employment-based, where what's issued to you is a conditional green card. So under even the immediate relative category of a U.S. citizen sponsoring their spouse, 2 years after the person has the green card for 2 years, there's another petition that must be filed to remove the conditions. And we see this pop up in the employment-based, at least one of the employment-based categories as well, but where they give the green card for 2 years, but then they say, okay, well, in another 2 years, in this case, they say that, well, we have to prove that the marriage still exists. So you have to provide additional documentation to show that. So sometimes it can be a 3-step process. The majority of the time, it's going to be a 2-step process. Under the family-based category, the petitions are always going to be an I-130 petition that's filed. And then if you're in the United States, you can do the I-485. And if not, you can do consular processing. And as I said, if you're in the United States, you can also do consular processing. It's a strategy decision or determination. Perfect. So now, now we're going to start to talk about the employment-based categories. And as I said, they run through EB1A through EB5. So the employment-based categories are, the employment-based categories are again, like, the criteria, we list the criteria, and when the criteria, when you look at the criteria, you're just making the determination as to whether or not you meet the particular criteria. So when we look at EB1A extraordinary ability, we what's happening here is this is a green card category that's really saying that the person has risen to the top of their field, right? So it could be in business, it could be in science, it could be in education, but you were really saying that this person has really made it and has really demonstrated that they've risen to the top of their profession. It's a very, very high bar. And what they do is they provide 8 criteria that you see listed here in the slide. And they say that if you meet 3 of these, then you could get the green card. So let's just look at one of them. So evidence that you've been asked to judge the work of others, either individually or on a panel. So when you look at American Idol and you see who are the judges that they use for American Idol, well, they're all people who have made it in the entertainment business, and now they're saying that they are like, I think that they are in a position to judge others to see, like, is this person has this person risen to the level of successful or good or talented, etc. So that, but for each of the criteria, that's what you're looking at. You're going to look at each of them and see if the person qualifies. As I said, it is a mechanism to be able to get a green card. Now, one of the things that's interesting about this category is that you are able to do what's called self-petitioning. The self-petitioning really, because if you don't self-petition, then what you end up having is a situation where you need an employer. But in this case, you don't need an employer. So let's say someone was coming to the United States to be an entrepreneur, or someone was coming to the United States because they were a world-renowned pianist. They don't need an employer to sponsor them. They can say that I plan on doing X, Y, and Z when I get there, and they can actually self-petition. Now, the forms that are filed, like, remember I said it's a 2-step process. This particular one is 2 rather than 3. But when we talked about the family-based, we said I-140, but I-130 rather. But here it's an I-140 petition that's filed. So the I-140 is going to be the petition that shows that the person has met at least 3 of the criteria that are listed above. And you can meet more. It's always better to meet more in terms of this particular visa category. Now, the other thing to comment on this particular visa category, this is one where we often see people, probably the most common non-immigrant visa that we see people moving from non-immigrant visa to green card is an O1. So a lot of the criteria that are listed here in particular are relevant or very similar to O1A. But what I'd say is that EB1A, even though the criteria look similar, what I would say is that, generally speaking, it would be O1 squared, right? So or more, because they are going to be looking for more accomplishment, more acclaim, more outstanding than the O1 petition. But definitely in terms of we do see people move from O1 to EB1, probably more so than moving from other non-immigrant visa categories. So again, what we said, with respect to the filing of petitions, if the person is in the United States, they can file an I-485 petition, or they can consular process. Now, EB1A is one category that is current right now for some individuals. It's not current for some. It's not current, I believe, for nationals from India or China, but would be current for everybody else, which means that you would actually be able to file the I-485. And just when I talk about what is current and what is not current, it's always important to check this. The government issues every month something called a visa bulletin. And the visa bulletin is what describes what is current. And it changes every month. So sometimes something can be current, as I mentioned before. We're kind of in a rush to file a few marriage petitions by the end of August, because for people who are marrying people that have green cards, because we thought, we had more time, but then the visa bulletin changed. The September visa bulletin is out already and says that category won't be current. So we only have until the end of August to actually file that petition, or the people wouldn't be able to file the I-485 petition. They'd have to wait until the category became current, which would be a problem for them. So, but in terms of if you were in any other, if you were born in any other country other than India and China, and I believe those are two countries that are delayed, then you would be able to file the I-485 and or start the consular processing process, because the category is current, which is really the next two categories that we're going to talk about is not the case for. So. Perfect. So the next category that we're going to talk about is EB2 national interest waiver. Now, before we get into the national interest waiver, let's just talk about the EB2 category first, because the EB2 category is really broken down into two types of green cards. So the first type of green card is a green card where someone is sponsoring you for the green card, and we're going to talk about that. We're going to talk about that in terms of a separate way of getting a green card. That's what we're going to talk about in the next slide. But then the other EB2 category is what's called national interest waiver. And the national interest waiver has three specific requirements that you see listed on the slide. But before we get to the national interest waiver, I do want to talk about the threshold considerations for EB2. So these threshold considerations apply whether a company is sponsoring you for a green card or whether you're going through the national interest waiver program. They apply for anyone who's coming under EB2. Now, when you're doing EB2, there's a threshold requirement that says that you have to have either an advanced degree or equivalent, and we're going to talk about equivalent means. An advanced degree means a master's degree or higher, right? So, and it doesn't have to be from the US, but a master's degree or higher. But it has to, if it's not from the US, it would have to be equivalent to a US degree. So master's degree or higher. Now, or equivalent, which is what they say is a bachelor's degree plus 5 years of progressive work experience. Right. So if you don't have a master's and you have a bachelor's and you can document that you have 5 years of work experience in the field that you plan on working in, that could work for you. Now, let's say you just have a high school degree and you don't have a BA and you don't have a master's, you don't have a PhD, then you can still qualify under something called exceptional ability. Now, this is different from what we just talked about, extraordinary ability. There is a separate list of criteria that goes through there, except 7 items, which are much easier to satisfy than the extraordinary ability criteria. And if you can meet 3 of those, then you can still qualify under the threshold consideration or threshold requirement so that you can move to the next step. So we get a lot of calls from people who say, oh, well, I see the exceptional ability criteria and I can easily do that. So I must qualify for a national interest waiver. But that's only step 1. That's the easy part. Because because all of these are or as well, right? If you have a master's degree, you can stop and move to the assessment of whether you meet the 3 criteria that are listed in the first bullet point. But it's only if you don't have a master's or you don't have a bachelor's plus 5 that you would move to exceptional ability. And if you were able to meet 3 of those criteria, then and only then could you move to looking at whether or not you satisfy the DANISAR or the national interest waiver requirements. Now, the other thing I want to point out is that, whether it's EB1, the family-based, or any of the categories that we're going to talk about today, we have separate webinars on all of them, right? So EB2 national interest waiver, we have a webinar where we talk for an hour about national interest waiver, and you can either go to our YouTube channel and look up older videos, or you can sign up for a webinar that we will have in the future, because we have them quite regularly. So what we're doing here is just really touching on what the requirements are. But so the national interest waiver requirements, they're based on a case called DANISAR that you see on the slide. And you have to prove 3 things. So the one thing you have to prove is that, whatever you're coming to the US to do has national importance and substantial merit, right? So it could be that what you're coming to do is create jobs. It could be that the government has indicated that they feel that this particular thing is very important. It could be that you have expert letters that demonstrate that the government believes that this would be important, or it could be articles that the government has written about themselves. There's one very popular case that we use often about a small consulting company, and it was a company set up to assist vets that were returning from combat and integrating them back into society. And there was a lot of documentation from the governments, from them saying that they felt that was important. So that's going to be very important for this type of petition. The second kind of thing that we're going to look at for the second requirement is that the entrepreneur or the individual, this kind of example is going through an entrepreneur example, but the individual is well positioned to advance the proposed endeavor, right? So the this sounds like it would be easy. We look at things like education, work experience. We would look at all of those types of things, but really what the government is that they want more than that, right? They want more, that they want more to show that the person is well positioned to advance the endeavor. So we would, if it was an entrepreneur, we'd include a business plan, but they want to, they want to see that the person has a track record of doing it before. They may want to see that if it was an entrepreneur, they may want to see that the individual has been accepted in an incubator, or has investment from other people, or the company is well capitalized. So they do really want to see that there's going to be a good chance that this is going to succeed. If someone's on, we do a lot of moving people from the visas, the non-immigrant visas that we move people from in this category is often E2. So a lot of people are on an E2 visa, and then we've moved them to national interest waiver. And in that, in that instance, we, the business is already running, right? So we're showing the government tax returns, we're showing them employee reports, we're showing them contracts that the company already has. If we're, for example, relying on jobs, or relying on, we just want to show that what this person is doing is significant, even though it may not have risen to national level yet. That it could. I say national level big enough that it could do that. So that's but E2 is probably the primary one, but it could be others as well. The last thing that we do is show that the government should waive the labor certification. So we're often pointing to many of the things that we're pointing to in 1 and 2, requirements 1 and 2, but then also pointing to any other positive factors that the individual has, right? So that's how we kind of do that. Now, the other really great thing about this is this particular petition is just like the EB1, in that the individual can self-petition, right? So they don't need an employer, and they can self-petition. But I think the key thing to think about with this is that the very first thing that we ask clients that want to do this is that, what are you coming to the United States to do? Like, what is your endeavor? Like, you have to define what your endeavor is very, very clearly, and then we go from there, right? So, like, do we think that the endeavor is in the national interest? And that's, it's not for us to say, right? That the client provides us with information with respect to why it is they feel that the endeavor is nationally important, right? Like, the immigration lawyer can't look up why something's important or not. The client would provide that to us, as again, in the form of expert opinion letters, or articles that from sources that support the fact that the assertion that the government actually does find this important. So perfect. So here we move to EB2 and EB3. So EB2 and EB3 that are outside of national interest waiver both relate to the same thing, but just the type of job might be different. Like, EB2 would be geared more at professionals, and EB3 might be geared more at unskilled workers and other categories. So, but keep in mind, if you're doing under EB2, like, let's say a lawyer is being sponsored by a company, then the first thing we have to look at, threshold issue, and lawyer's going to be easy because they have a advanced degree, master's degree or higher. And but if it's another category, you have to first be able to, or you might have to apply under EB3, which might create problems. But this is a category where many of our clients move to green card, right? So whether they're on TN, whether they're on L1, whether they're on H1B, because this is the category where the company is just sponsoring the person for a green card. You can have a nanny and sponsor a nanny for a green card, right? You may not get approved, but it's anyone. There's no requirement that the person that you sponsor has to have high school education, or there's a category that's called unskilled workers that can be used. The key with this, though, is that you do have to show that the company could not find a qualified US worker. And that's why sometimes, like when I use the example of nanny, it might be difficult, right? Because if you wanted to sponsor a nanny for a job and then you had to prove to the government that you couldn't find a qualified US person, and not, I don't mean the nanny that you want. They don't care about that, right? The fact that you know her and she's good with the kids, he or she is good with the kids, that doesn't matter. For perm, that doesn't matter, right? They're saying that, let's say educational, usually the requirements have to be stripped down to educational requirements and experience, right? So if you said, okay, I want someone, let's say you wanted someone with a bachelor's degree, and you said that I also want a nanny that has he or she has 2 or 3 years of experience, right? So now the question is, are there qualified U.S. workers who have that? And the process is quite an extensive one, where you actually have to go through a process where the company is posting ads in newspapers and other places, and people apply for the job. There is no real job, right? But they apply, and then you go through, and you can't disqualify them for reasons that aren't, like I said, that the reasons you can disqualify, if you say the job needs a bachelor's degree and they don't have it, or the job needs 2 years experience and they don't have it. Those are reasons you can disqualify. You can't, their interpersonal skills weren't good, or anything like that. That none of those reasons can be used to disqualify. Because remember, you're not hiring them. This is all an artificial process to see if you can, if the job can find qualified U.S. workers. So then there are a number of different things with respect to perm. We have a separate webinar on this that make them riskier. Some of them are listed on the slide here. And then again, the process is the same. An I-140 is going to be proving the piece. It's similar. I don't know if I mentioned it I don't think I mentioned in the EB2 national interest waiver, but it's an I-140 petition that's filed. And then depending on whether the category is current or not, you could file an I-485 or do consular processing. And keep in mind that family members can all join in these processes. So if a family member means spouse and child under 21 can join in these processes. So if you're getting a green card and the spouse or children meet those criteria, they can join in that process. Perfect. So now here's a category that we do a lot of as well, and we move a lot of people from non-immigrant visas to green cards using EB5. Now, I'd say that it's quite a wide range. We move people from TN, we move people from E2, quite a wide range, I would say, H1B, L, because the key here is that the person has money to invest, right? So the regional center program allows you to invest passively, so invest passively in what's called a regional center, or to invest in your own business or a business that you're going to be a part of. Now, when the individual is investing in their own business, often we move people from E2 to a green card, and they're investing in their own business, and that works out well. But we've also had a number of cases where the person has been on an E2, or I think I was speaking to someone just the other day, the person was on TN, and and they invest in a regional center and get a green card. So you're going to either invest 800,000 or 1,050,000. The difference is going to depend on where the job is located. So if it's located in a targeted employment area, then you can invest the lower amount, and if not, the higher amount. This is a very, very technical category, so I'm not going to spend a lot of time. As I said, we have a separate webinar on EB5 investment, but it is a very, very technical category. I think the key things to keep in mind are that you have to make the investment. And then the other kind of key thing to keep in mind is that you have to create 10 full-time jobs. So the 10 full-time jobs have to be U.S. citizens or green card holders. And when we're moving people from E2, it's often a complicated exercise, because we have to look at what amounts can be included in the investment, because some things can be included for E2 but not for EB5. We also kind of have to look at how the E2 was originally obtained. Was it a business purchase, or was it something else? Because a business purchase isn't always going to qualify. And then the source of funds is another big thing with EB5, that you do have to show that you are able to, you have to be able to show that where the money came from, and that's quite an extensive exercise. So definitely not for the faint of heart. In terms of this particular petition is a 3-step process. So it's the equivalent of the I-130 and I-140 is the I-526 petition. So that's step 1. Then we have the consular processing, or I-485. That's going to be the same. That's the same regardless of which green card you're applying for, of the categories we've talked about. And then the third process of removing your conditions is what's called an I-829. So 2 years after you get the green card, you have to file more paperwork to remove the conditions, because they want to make sure that you have created the US jobs. Perfect. So these, we other green card options. So what's interesting is, some people have all the luck, right? Because we do at least one diversity lottery case for our current clients a year, right? So someone who's a current client on an E2 or something and wins the lottery. I think Dustin's working on a case right now of one of his E2 clients who, I don't know if you're doing the diversity case, but one of Dustin's E2 clients this year in May won the lottery, the diversity lottery. So we're now doing the green card application for her. She won't be eligible to get the green card until June or July of next year, but we're doing the green card for her. And I'd say that happens at least once a year, where one of our clients wins the diversity lottery. It's incredible. So that, that's something definitely, some countries are not eligible, but many are. So that's something in October. It's free to apply. It's easy to apply. You don't need a lawyer to apply. For the initial selection, you just have to, if you can follow simple instructions, you don't need a lawyer to apply. If you win, then I think that you would want a lawyer after that to take a look, to take a look at what how to put it together, because it becomes a little bit more complicated. It becomes a little bit more complicated after that. Perfect. So then there's some humanitarian-based green cards, and sometimes with spousal abuse, that can lead to a green card. There are other situations. I think Dustin's working on a case right now where the person witnessed a crime and assisted the police, and that's a road to a green card. They're not that common. Like, I'd say these ways are not that common. But it's definitely something to keep in mind, because we have worked on humanitarian-based green card cases for our clients. This person that we're looking at here was an E2. The person who saw crime was an E2 client, but so definitely good to be aware of some of these other options. So, and then we always hope that one day that point space system that I talked about earlier will actually be in place in the United States. So the thing I think to always keep in mind is, because when you have a non-immigrant visa, when it's a TN, E2, or whichever it is, there are going to be timing considerations that are going to be very important, in particular because of what I talked about. Some of the categories are delayed. But also, some categories take a long time to be approved. EB5 petitions are taking 4 or 5 years to be approved. So you have to make sure that you do have some underlying status. So if you are national from, depending on where you're national from, because the EB5 category, the current aspect is complicated, right? But depending on which country you're from, you could have a long wait. So you have to make sure that you're able to maintain status, and to the extent you want to travel, et cetera. We do have, then the other thing to kind of keep in mind is, depending on your immigration status, if you're like on an L, an H-1B, or even an O to some extent, you can have the intent to adjust status in the United States. But if you're on an E, a TN, or others, you can't. So you can't enter the United States with an intent to adjust. So you have to be careful with respect to planning things out, like if you're starting a green card process, like, you want to make sure maybe you've just renewed your TN if you want to start a green card process, so that you have the maximum amount of time on the TN. Because when you go to renew the non-immigrant visa, if it's not a dual intent non-immigrant visa, then you could have difficulties once they know you started the green card process. And we often do have people who do parallel green card strategy, so that's good. That it's no problem doing that at all. We just had we have a client who we're doing an EB5 for, and it looks like and his was approved. His was approved. I have Dustin here who was taking a really long time for his case to be approved, and our client decided to sue the U.S. government, and Dustin handled that case and was able to get the case adjudicated and approved. And now he might, I think he's getting married. He may marry a U.S. citizen, right? So with that, we're going to stick with the EB5, right? But the person now has a different green card strategy or option available to them, which might be faster, a lot faster. So, and we do have clients that have multiple green card. Look, when I say multiple, two, I don't think we've ever seen one with more than two, but we do have clients. You have another client where they have an approved EB5, but then they're probably eligible for a national interest waiver as well. Now, and we look at it because the benefits are, if someone is eligible through marriage, they would get the green card a lot faster, and then also they're eligible for citizenship in 3 years. If you same thing with national interest waiver, you don't have to remove any conditions if you have a national interest waiver green card, so that's going to be a lot faster than EB5 as well. So with EB5, you're going to be in the system for 8, maybe 10 years. Still with a lot of benefits, right? A lot of green card benefits, but you're going to be in the system for a long time. So, the key planning is really key for all of this.
Absolutely. And Ian, we have received a question, and I'll take
Sure.
the opportunity to encourage others to send in questions if you have them through the question and answer box or the chat function. But the question we've received is really applying what you were talking about before about timing considerations. So let's just apply it to this example. If someone has an E visa and they apply for an EB3, what issues might come up when they go to renew their E visa?
Yeah, so I mean, it depends where they are in the EB3 process. So the EB3 process has kind of distinct aspects. So one is the PERM process, where you're going through the labor certification process, trying to prove that you can't find a qualified U.S. worker. Now that can take a year, or actually usually longer. So it shouldn't say a year. That could take a year and a half just to do that. At that point, I don't see any issues with renewing the E2. I think, sorry, with renewing the E2, I don't think there'd be any issues. Now, if the company, because I'm assuming the person has an E2, but some other company offered them a job, or their spouse got offered a job. And now, if the I-140 was filed, if it was the spouse, I think again would not impact the individual. I think that the issue would come if the I-485 or some other. If the I-485 was filed, I think that's if they were in the United States and they had to renew their E2 at that point, and they wanted to renew it outside of the United States, they can still, within the United States, they can file an extension, even with a pending I-485 for that particular petition, an E, not a TN or others, but for that particular petition, you can still, if you're in the United States and you have a pending I-485, you can still file an E2 extension in the United States. But if you had to go to the consulate to try and kind of renew the E2, I don't think actually, with the pending I-485, I don't think they would renew it. Even if, because obviously if you have travel authorization. But by that point, if you're that far down the process, if you have the pending I-485 and you have work authorization and travel authorization, then you may not even need the E2 renewed, right? So.
Perfect. And I believe that is all the questions we've received. One more came in.
Yeah.
Are there any options available when a parent is a U.S. citizen where the child was born out of wedlock, And the father was not aware of the child before they turned 21. This is a very nuanced family-based question. Ian, I'm not sure if you have anything to say about that one, but I'll
No,
just give a general make a general point, which is, if you do have questions about your specific circumstances, and frankly, this one is getting quite nuanced, please do schedule a consultation. We make that process very easy on our website to schedule a 30-minute consultation, and we can get into the details and really give you some actually quality guidance rather than on a webinar where we can't really. But Ian, if you had
yeah.
anything else to
No,
add.
no, I don't. I don't know the answer. But what I'd say is that if you're setting up a consult with us, just set it up with someone by the name of John Barrera, and he can go over whatever kind of, whatever options there are that are available, if any, they could go to that. What are the success rates of going from a TN visa to a green card? And if you don't get approved, does it affect your TN status? Yeah, great question. Okay, so so I don't know if I don't know if there are any kind of published kind of statistics on, someone moving from a TN to a green card. They publish statistics by green card category, but even just by green card category, that approval rate of XYZ. But even with the green card category statistics, they don't even break them down very well. Like, so for example, EB2, when they say, I think it's 80% approval rate or something like that, that they don't break it down between EB2 PERM and EB2 national interest waiver. So, so what I would say is that all of the categories that I talked about, with the exception of, sorry, no, all of the categories, what I would say is that when we put together cases for all of the categories that I talked about, we are often not surprised by the result. Right. So some of the categories are extremely objective, right? EB5 is extremely objective, right? So that's and same thing with, to a lot of extent, companies sponsoring you for a green card, right? That's even if the perm didn't get approved, usually it's not that the perm won't get approved, it's that as they're going through the process, they may find a qualified US worker, so you have to stop the process. But a very objective process, right? Because when you keep in mind that what a perm is saying, that the job needs a bachelor's degree, like this could be a perm, right? The job needs a bachelor's degree and the person has it. Right? And then we couldn't find a qualified US worker. That's the criteria, right? There's not. Now, some of the more subjective categories like national interest waiver and EB1, they are a very high bar, but I think that as we're putting together those petitions, we are, we've had great success with both EB1 and national interest waiver. Like, past results don't predict future outcome, but I don't believe we've ever had a national interest waiver or an EB1 case denied. But I think that the key is that we're putting together cases that are good cases, right? I think that as people go through the consultation process, like, I get a lot of people setting up consults for national interest waiver saying, I'm a pilot and I've been a pilot for 10 years. Can I get national interest waiver? And I says, well, is there anything else? And then not really, right? And those are going to be very, very difficult cases, right? So we explain all that before, because we don't just kind of submit an application and hope for the best. Now, but I do think the second part of your question about, does it affect your TN? So let's say you apply for EB1A or national interest waiver, and your petition gets denied. I think that it could affect the TN, but not necessarily. I think it depends on how you apply. Now, if someone had a non-immigrant visa that was not dual intent, we'd probably encourage them to just file an I-140, right? First, not even if they're in the United States, not to file the I-485. Now, if the I-140 was denied, then I think that it could affect your TN in the future, but I think much less likely, because you have not signaled any intent to adjust status in the US. I think that if you filed an I-140 and an I-485 and then they were both denied, I think it's more likely that could affect your TN when you go to renew. But but as I say, as a generally speaking, the advice I typically give clients is the advice that like I'm in the US on a visa myself. I've been on a TN, I've been on an F1, I'm on an E2 now. And the advice that I give clients is the advice that usually I would do myself, right? I don't think for any of these categories that we talked about, unless you have a bad case, right? Because that so we can tell you when that we can tell people that as they come to us for consultations. Unless you had a bad case, I don't think that the risk of not getting the TN approved in the future would be enough, unless an individual is extremely risk averse, right? Would be enough to not apply for the category if you actually had a decent case, right? That's yeah. I think so the answer, it could impact, but I think that we put together a petition to kind of mitigate that, mitigate that impact, mitigate the risk of any significant impact. Like I said, for example, filing just the I-140 rather than the I-485, and then premium processing it, right? So you have an answer quickly, and then if you have if you get approved, then we can file the I-485 right after that. So
Perfect. Thank you very much, Ian. Well, Ian, thanks for sharing your expertise, your
my pleasure.
experience, and to
My
our
pleasure.
audience, thank you for the excellent questions. Please do keep an eye out for our follow-up email with a link to future webinars, the PowerPoint, and a link to our YouTube channel, and we hope to see you on future presentations. Thanks so much.
Great. Okay. Thank you very much, Dustin, as well. Thank you. Bye.